In Washington, timing is never an accident. 7 days before the Justice Department's legal deadline to release Jeffrey Epstein investigation files under a new transparency law, Congressional Democrats have dropped a fresh batch of photographs from Epstein's estate, and front and center in many of them is Donald Trump. 19 images pulled from the disgraced financier's properties show Trump, Bill Clinton, Steve Bannon, Bill Gates, Larry Summers, Woody Allen, and other powerful men in casual and social settings linked to Epstein's world. They are not criminal evidence on their own, but they are political TNT, detonated just before the files clock hits zero. The images were released by minority members of the House Oversight Committee, led by Democrat Robert Garcia, who accused the White House of a cover-she-up and how it has handled Epstein-related records. In statements, Democrats said the photos raised further concerns about how closely Epstein was intertwined with some of the most powerful men in the world, and demanded that the Justice Department immediately comply with the new law requiring broad document disclosure. That law, often called the Epstein Files Act, was passed by Congress last month and signed by Trump himself after internal resistance from his own aides. It requires DOJ to release by December 19 a wide range of investigative materials from Epstein's 2019 sex trafficking case, subject to redactions to protect victim privacy and ongoing probes. Until recently, grand jury records from that case were considered off the limits. Grand jury secrecy is a bedrock of the U.S. justice system, meant to encourage witnesses to speak freely. But a federal judge in New York, Richard Berman, has now ruled that the Epstein Files Act unambiguously overrides previous secrecy orders for this specific case. In his ruling, Berman said the law clearly intends to make Epstein-related grand jury and discovery materials public, while emphasizing that victim safety and privacy remain paramount and must be protected through careful redactions. He reversed an earlier decision where he had kept the material sealed out of concern for victim safety, explaining that the new statute changed the legal landscape. That means DOJ is now legally authorized and obligated to unseal transcripts and exhibits that would normally never see daylight. The White House did not embrace this transparency immediately. According to reporting, senior Trump aides initially opposed the legislation, warning that broad dumps of Epstein records could include explicit material and could be construed as distributing child pornography if not handled carefully. They also worried about collateral damage to people only loosely connected to Epstein and about national security implications if intelligence contacts appeared in files. Under growing pressure from Congress, from parts of Trump's own base, and from broader public opinion, Trump eventually dropped his opposition, allowing the bill to pass and signing it into law. That sequence is now being used against him. Democrats argue that if he truly supports transparency, there is no reason for DOJ delays or narrow interpretations of what must be released. Republicans on the oversight panel have a different complaint. They accuse Democrats of weaponizing the photos to score political points, noting that the images include figures from both parties and various industries. From their perspective, releasing pictures of Trump, Clinton, Gates, and others together days before a document deadline is designed to shape the narrative before any actual evidence is reviewed. They warn that the public may conflate mere social proximity, being in the same room at the same event, with criminal involvement long before investigators or courts weigh in. That's a real risk. In an age of viral images, nuance dies quickly. A grainy photo from a party can be enough for half the internet to decide someone is guilty. The judge's ruling tries to balance those dangers by explicitly instructing DOJ to follow the statute's privacy protections. Berman is saying, release the substance, not the trauma. Names and identifying details of victims can and should be redacted. Sensitive leads still tied to ongoing investigations can be withheld, but the default has flipped. Secrecy is no longer presumed. Transparency is. For decades, powerful men connected to Epstein relied on sealed records and legal settlements to keep details out of the public record. That era is ending, not because elites became more virtuous, but because Congress and the courts have decided that in this one case, the public's right to know outweighs the usual confidentiality rules. For Trump, the optics are brutal but ambiguous. On one hand, he appears in new photos pulled from Epstein's estate, just as a law he signed forces the release of more documents. Opponents will draw a straight line: photos today, files tomorrow, scandal soon after. On the other hand, the images themselves, based on current reporting, show him in social settings, not committing crimes. He can argue, as he has before, that Epstein circulated in elite circles, that many people crossed paths with him, and that proximity is not proof. Supporters will note that Clinton and others also appear in the files, and that the law's Victims Die First protections suggest Congress expects disclosure to be messy but necessary, not clean and partisan. For the system, the next 7 days are a test. DOJ has to move fast to process, redact, and release documents under both the statute and the new court order. Congress will be watching closely, and if the department tries to dribble out only a small subset, expect hearings, subpoenas, and more photo dumps. Victim advocates will push for maximum sunlight without re-victimization, a difficult line when the public is hungry for names. Political operatives on all sides will comb every release for ammo, an email here, a guest list there, a travel log connecting the wrong people at the wrong time. The real question is whether the country can absorb disturbing truths about how Epstein operated without turning every photo into a weapon and every acquaintance into a suspect. From a Buffett mindset, the takeaway is not which politician gets burned. It's how institutions handle scandal under pressure. In this case, Congress wrote an unusually aggressive transparency law. A judge enforced it even against long-standing grand jury secrecy. The executive branch is being forced to comply on a tight timeline. That shows both the strength and the stress of the system. Strength because branches are checking each other and victims' rights are being elevated. Stress because the same tools that expose real wrongdoing can be used to smear the innocent if context is lost.